Do you actually know what you're looking for when you're searching existing patents and trademarks? In this video, I'll explain to you what a patent, trademark, and copyright is, the difference between them, and what they actually protect. So when you're looking at patents and trademarks, you'll understand what you're looking at and what to look for and avoid so you don't get sued. Stick around. What's up, guys? Crescent here, and welcome back to my channel where I share with you the best tips and strategy videos just like this one on how to succeed with Amazon private labeling. So if you're new here, consider subscribing. Let's get started. First off, I want to make a disclaimer that what I'm about to say isn't legal advice. If you have legal questions, consult a professional lawyer. Okay, let's get started. So why is it important to make sure the product you're looking at doesn't have any intellectual property claims? Well, if it isn't already obvious, if you're in violation, in the best case scenario, you'll lose your investment in the product as you won't be able to continue to sell it. In the worst case, the property rights owner will sue you until the cows come home for damages. So make absolutely sure you do your due diligence. So what is a patent? There are 3 types of patents, but only 2 of them are of concern when doing Amazon private labeling. The 2 are utility patents and design patents. The 3rd has to do with plants. The fundamental difference between a utility patent and a design patent is this. A utility patent protects functionality, how something operates or works, whereas a design patent strictly covers the physical appearance of something, anything that's non-functional. Let's use a simple example, like this paperclip. Let's say I invented the paperclip and I was granted a utility patent for it. What would this patent cover? If you want to test yourself, then pause the video now and think about it. Okay, remember, a utility patent covers functionality. So what does a paperclip do? What is its purpose or function? A paperclip is designed to hold pieces of paper together. So the utility patent would cover this intended use or function regardless of what the actual clip looked like. Basically, any device that clips pieces of paper together would be protected by this patent. But again, this is just an example, and the actual wording of the patent would dictate what the patent would actually cover. Now, let's say I also applied for and was granted a design patent. What would this cover? Again, pause the video now if you want to think about it and test yourself. Okay, remember, this time a design patent covers anything non-functional, the physical appearance of something. So the patent in this case, for this specific paperclip, would cover a clip that is looped 3 times in this exact shape. So if someone added another loop or bent it into a triangle shape, for example, then my patent wouldn't protect me. But here's the catch. Because I also have a utility patent, even if someone bent their clip into a different shape, they cannot claim to use their clip for binding pieces of paper together. It must be used for an entirely different purpose and absolutely cannot be confusingly similar to what is covered under my utility patent. For example, their clip can be advertised as a piece of jewelry or a hook to hang Christmas ornaments or something like that, but they cannot advertise its primary function as a paper clip. Otherwise, it would be infringing on my patent. Make sense? Now, utility patents are extremely difficult to get. 90% of utility patents are rejected. Why? Because whatever the functionality is that you're applying for must be specific and not commonplace. For example, I can't apply for a patent on a chair. Otherwise, any device that someone sits on would fall under my patent, and it just wouldn't make any sense. But a design patent, on the other hand, is very easy to attain. 90% of design patents are approved. Why? Because you're simply protecting the physical appearance or shape of the product. Do you know who has one of the most design patents? Apple. Every single product in their product line has a design patent because the shape, the form, and the look is Apple's brand image and identity. Anytime you see an Apple's product, you recognize right away that it's one of theirs, right? But at the same time, Apple also has a ton of utility patents because they're also at the forefront of technology and they're always coming up with new and innovative ways to do things, such as Touch ID, gestures, and how sensors are used and placed on their devices. Those would all be protected under a utility patent. Okay, so I'm not actually going to go through how to search for patents online. You can do extensive patent searches with Google at patents.google.com or on the US Patent and Trademark Office website at uspto.gov. Since now that you know what a patent is, you should be able to look at the patents and discern if the literature and the drawings are describing any function, part, or appearance of the product that you're interested in selling. One thing to note though, just because a product or listing doesn't say patented or patent pending doesn't mean that the product isn't patented. It's not required by law to disclose that a product is patented on the product or advertisement. It's also against the law to claim that you have a patent when you don't, so don't do it. Moving on. So even if you've been extremely careful and you're not selling a patented product, you can still get hit with an IP infringement claim over trademarks and copyright. So what's a trademark? A trademark is how the world identifies or recognizes you or your products. It's your brand name or logo, like McDonald's and their golden arches, Nike and the swoosh, or Apple and the apple with the bite taken out of it. A trademark can cover the name, the image, font, or associated colors. Now, you don't have to register your trademark to be protected. Common law trademark is automatically in place the moment you start using your brand name or logo. So you can claim that you've been operating your business using your brand name or logo since some start date, and anyone trying to use your same name or logo won't be able to. This is where you might have seen the TM symbol next to brand names used in advertisements and signage. So if you haven't registered your trademark, you should put the TM symbol on your brand wherever you're using it to show that you're operating under that trademark. If you have registered your trademark, then you should go ahead and use the R symbol next to your trademark. But don't do that if you haven't registered. It's against the law. Additionally, trademarks can't be confusingly similar to someone else's. For example, I can't be in the personal electronics industry and use a logo that's an apple with no bite taken out of it, as it would be too similar to apples. I recall reading about a guy named Mike Rowe who was a web designer, and his business website was mikerowesoft.com, and Microsoft sued him. Another example is t-shirts with Batman or Star Wars logos on them. Unless you have a license or purchase the product from a licensed wholesaler, you can't just go and print your own t-shirts with Batman and Star Wars logos on them. That's the fastest way to get yourself sued. Don't do it. With that in mind, even if you're not violating someone's trademark, be extremely careful using someone else's brand name in your listing. If you must, at the very minimum, put "not affiliated with so-and-so" in your listing somewhere. Lastly, what is a copyright? Copyright protects any piece of artwork or literature, such as a photo, a painting, poem, or a piece of music, like songs from the Backstreet Boys. You can't reproduce them without permission. Photos, for example, even if you modify them, the original photographer still has the copyright on the image. Same with music, like when Vanilla Ice got sued by Queen. Just like with trademarks, common law takes effect as soon as the photo, literature, or music is created. To help protect yourself, Amazon doesn't like you putting watermarks on your photos, so what you can do is use the copyright C symbol somewhere on your images and packages, or if you have an insert card or an instruction manual, put it in there as well. Okay, let's bring it all together. Patents take time and can be pretty expensive. So are trademarks, which can take 8 months or longer to attain. For Amazon FBA, that's why it's essential that you private label your products. Come up with a brand or logo for yourself and put that brand or logo on your products so other sellers can't hijack your listings. It might cost you a little more money up front, but it will help protect your investment in the long run. And if later on you decide to register your trademark or patent, you can. Now, what can you do if you find someone infringing on your intellectual property on Amazon? Contact the Seller Support Catalog Department to report any violators who have copied your images or listings. Also send them a cease and desist letter. Have a professional lawyer draft a letter for you, or you can find a template online. I'm not going to provide one for you to download, so don't ask because I don't want to get sued. Just Google it, you'll find one. Okay, so what can you do proactively to protect yourself of any IP infringements? Have a conversation with your suppliers about IP infringements. They may actually already be aware that the product violates certain IP claims, but they're not disclosing it. Trust your gut and avoid the supplier if you're not comfortable. IP infringement is a serious offense and can get your listing suspended or your account shut down. If for whatever reason you do end up getting a cease and desist, take care of it right away. Don't just sit around thinking it will go away because it won't. Seek professional counsel to make sure the claim has merit and so you don't get bullied. What you can expect from a cease and desist is they may want you to stop selling immediately or stop using their trademark or copyright. They may want to know who your supplier is and how many units you sold so they can determine compensation or settlement. They may also want you to destroy however many units you have left in stock. So I advise that you seek professional help to make sure they aren't overstating their claim. Okay, so now that you know what to look for, like I said before, you can do searches on Google and on the US Patent and Trademark Office website. But again, just because you didn't find anything doesn't mean there isn't a patent or trademark. So hire a professional to do a search for you. Don't get sued. If you found value in this video, please consider subscribing and give it a thumbs up or share it with a friend. I'd love to hear from you too, so leave a comment or question below, and if you haven't already, join my Amazon Facebook group. There's a link in the description. And as always, thanks for watching.